Thank you very much, Mike, for having me here today. And it's really interesting to hear what Kenya has been up to. Regardless of what continent we're in, we are beginning to see that we're gradually becoming borderless, especially in the digital space. And as it turns out, as you had already alluded to, Nigeria is barely 3 years that it's joined the League of Nations with a competition regime. So as a matter of age, we would probably be considered toddlers. However, I must say that we've made some giant strides in establishing a competition regulatory framework, and we have taken cognizance of more developed institutions in Africa and around the world. But let me start by talking about the FCCPC its scope and its mandate. And it's a very important starting point because of its dual mandate with respect to protecting consumers and also ensuring that we have a level playing field for all businesses. And the scope spans across all commercial activities in Nigeria. And so we're able to enforce any enactment that bothers on consumer protection or competition in Nigeria. And as Chief Legal Officer with the Commission, I've had the privilege of and experience of recognizing that the competition issues agencies that we have somewhat have very similar objective with respect to regulatory framework or enforcement. And so although we're constantly learning, we've come to understand that the bedrock or the most important aspect of competition analysis is sustaining the key pillars, whether it's price, quality, output, or choice or innovation. And so we recognize the benefits of the digital market as alluded to by my colleague from Kenya, and we know that we cannot overstate it. However, we know that we recognize the unique characteristic of that market, and we have seen some of the challenges, whether it's with respect to mergers, how the market is defined, how we assess market power, and the question remains whether competition law can deal with these challenges in the digital sector. I will say that there are no direct answers to this, but we have found in Nigeria that we must be a bit more flexible and adaptable in how we interpret our local laws. In other words, to properly regulate competition and consumer protection in the digital space, we as regulators must begin to see data for what it is. It is now the new currency. And so we have had to look into how this data is collected, how it is democratized, stored, and the issues of interoperability and consumers' choice and consent. And so it raises a lot of concerns. Nigeria is currently investigating the digital money lending space, and we have taken a different approach beyond regulation. We have decided that collaboration is key. We are collaborating with other sector regulators like the Central Bank of Nigeria, the Nigerian Communications Commission, and other stakeholders, the Nigerian Data Protection Bureau. And we've come up with an interim guideline where we've set up a joint task force, and we're asking businesses to come and assess their business process, how they go about carrying on their business. One of the key problems we recognized in that sector was the access to consumers' data and how they were able to share this consumer data with third party. And this is because the digital money lenders had access to their phones, to their pictures, and all of that. And so we began this investigation by setting up a joint task force. We froze some of the accounts of the digital money lenders through getting a court warrant and issuing orders to the banks. We also pulled down some of these apps from the Google Play Store. And currently we have given a 90 days ultimatum to all these digital money lenders. And just like in Kenya, it was difficult for us to know who these digital money lenders are. Just the sheer characteristics of the digital market. It's difficult when you don't have a fiscal infrastructure on ground. It became a concern. And so we recognize that a lot of these platforms, apps, applications, we're using the Play stores or the application stores. And so we wrote to them and we immediately put a 90 days ultimatum that they should immediately ban any other digital money lender that isn't currently registered on their platform if those money lenders have not gotten a waiver from the Federal Competition and Consumer Protection Commission. We went ahead to also give a 90 days ultimatum to those currently on those platforms who are already set up and there are no complaints against, but we gave them 90 days to come before the commission to register their interest in doing business in Nigeria, and we will issue waivers to them. But more importantly, we've been speaking with the Nigerian Data Protection Bureau, who is responsible for privacy issues, privacy policies, data collection, how auditing these data service providers. And currently they would be participating in the how the guidelines are implemented. And so this is just some of the concerns that we have seen. With respect to other aspects of defining the market, the Commission has only recently issued its market definition notice and has taken cognizance of the digital markets. Specifically, even with respect to zero-priced markets, the Commission has stated that the fact that it's zero price does not necessarily mean that it is free or that it comes at no cost. And so we're looking at other tools outside our usual tools, which would be, say, the SNP test. And we're considering the costs to consumer, the privacy issues that it raises, the potential decrease in quality, whether it's the disruptions in advertisements or not. And just like I had said earlier, one of the key responsibilities of the Commission is the power to, enforce any enactment that bothers on consumer protection or competition. And so we're able to enforce the Nigerian data protection regulations with respect to consumers giving consent to how their data is used and the fundamental rights of the consumer to own their data and control their data and how it is used. And in certain instances where they intend to withdraw, we're looking at that. And the ability to make that data accessible to others. Specifically, we have also earlier on this year, the Commission has come up with its abuse of dominance regulations, where it was very clear how price would be determined and how the Commission intends to look at other parameters that can influence the dominant undertaking for their benefits. And we're looking at other things like I said before, data, access to data, quality, and innovation. And just like Kenya had said, we do not intend to be a barrier in terms of regulation, but we want to ensure that there's at least fairness in the market. And so we would be looking at a situation where data is commercialized, for example, and will be the interpretations that we want to give to how the market powers are looked into, subscriber base, and all these things, whether it's how do we arrive at market power. And these are conversations that are going to be had with the new abuse of dominance regulation that is out. So we've also begun an investigation on one of the big tech companies with respect to their refusal to grant free their refusal to grant consumers their rights to consent freely. I mean, their case is that they've granted consumers consent, but from the analysis that we've received so far, it was a decision made on behalf of the consumers. It's a take it or leave it option. And they have indirectly ticked the box for the consumers. And so we're currently looking at that case, and we've been able to consider other tools like the small but significant non-transitory decrease in quality as a tool, or a non-transitory increase in cost, whether it's with respect to the consumer's ability to switch to other platforms, or it's the ability of a consumer to say, you know what, I want to withdraw my consent. I don't want you to share my data with other third parties. And we're still looking at that. But again, the Commission has taken 3 approaches to how it regulates the digital space, whether it is by issuing regulations, enforcement, or collaborating with other local or international competition agencies. So, for example, we've currently just entered into a memorandum of understanding with the Competition Commission of South Africa. We are currently looking into one with the Egyptian Competition Authority. And yes, like I said before, we had set up a task force for enforcement with respect to the digital money lenders.